The University College of the University of Maine system, together with the Maine Department of Labor, Bureau of Labor Standards, has formed a partnership to make public information more accessible to Maine's employers. This is the second part of Section 3. It was divided into two parts due to the length of the file. Steve Laundrie was discussing pre-existing conditions and significant aggravation. So we now return to his lecture.
As with the 1910 and 1926 standards, there are exceptions to rules regarding what is considered to be work-related. The next few slides I will be going over what are some of these exceptions. The first exception listed under 1904.5 is if an employee is present as a member of the general public. This would occur if an employee is works at a grocery store or some sort of retailer, and they would come in solely to shop. In that situation, if the employee is injured, say they slip on a puddle of water, that would not be considered to be work-related, therefore not recordable. The second bullet listed on this slide is one of the more common questions that I get regarding OSHA record keeping. That involves symptoms arising in work environment that are solely due to non-work-related events or exposures. I would encourage you to please circle or highlight that word solely. Solely means that this employee has some sort of condition not related to work that just happens to flare up at work. This standard was put in here to address issues regarding primarily epilepsy and diabetes. An employee may suffer an epileptic seizure at work. Nothing in the work site contributed in any way, and many epileptic cases wind up with the employee falling, creating a serious injury. In that situation, that would not be work-related, therefore not recordable. Same thing with a diabetic incident. Again, the employee may have diabetes. There may be a diabetic seizure while at work. In and of itself, that is not considered to be work-related, therefore not recordable.
Excuse me, what about a heart attack?
The rule is on heart attacks is it would depend on the situation. If something at the work site contributed to the heart attack, for example, physical demands and maybe even mental stress, then that would be considered work-related. If nothing at the work site contributed to that heart attack at all, then it would not be work-related. Now, if you have a question as to whether that heart attack, whether something at the work site contributed to that heart attack, you may wish to consult the physician or consult the employee themselves. Continuing on this same slide, the next exception to work-relatedness is voluntary participation in a wellness program, medical, fitness, or recreational activity. I would ask all of you to please highlight that word voluntary. This would involve situations such as a softball league, for example, where employees voluntarily participate. An employee gets hurt because it's a voluntary activity, it would not be considered work-related. Another situation is if you have a break room where there's a weight room inside your office, an employee on his break decides to lift a dumbbell and the dumbbell falls on them. Again, that's voluntary participation in a fitness activity, therefore it would not be recordable. A wellness program would be a situation where there is, say, a flu shot going on at your work site, and it's voluntary participation in flu shots. Employee gets an allergic reaction. That would not be work-related. Blood drives are another example. Now, I can't imagine a mandatory blood drive, but if there is a voluntary blood drive at your work site and an employee passes out, then that case would not be recordable. And finally, on this bullet, I mentioned recreational activities. This would be something like voluntary company picnics or some other voluntary activity that an employee it's not required that they attend and they get hurt at that activity, then it would not be work-related. Now, we're talking on this slide solely voluntary participation. That does not necessarily mean that there are situations which are mandatory. For example, you may have a work site where you have mandatory stretching exercises. If an employee is injured while participating in mandatory stretching exercises, then that would be work-related. Also, you may have employees who, as a condition of their employment, is to maintain a recreational facility, such as your janitorial staff. Also, you may have employees who are required to participate in physical fitness activities, such as gym teachers or certain types of law enforcement or other people where there are mandatory physical fitness requirements. Continuing on, the fourth bullet on this slide is eating, drinking, or preparing food or drink for personal consumption. I would ask all of you to please circle, highlight that word personal. This refers to a situation where an employee brings in their own food, slices an apple, and then slices their hand. Even if it occurs at the break room, that case would not be considered work-related, therefore not recordable. The next exception under 1904.5 is personal tasks outside of assigned working hours. This is such a situation where an employee after work does some sort of personal task not related to their work. For example, if an employee uses the employer's sewing machine to make tents for the Girl Scouts after the shift has ended, this is a personal task outside of assigned work hours and is not recordable. Also, if you have a auto repair facility and an employee brings in their hot rod and after work and the tire falls on them, breaks their arm, that would not be work-related. That is also a personal task outside of assigned working hours. Continuing on, the next other exceptions to the issue of work relationship involve personal grooming, such as makeup, hair, that sort of thing. Self-medication for non-work-related conditions. If you have an employee who has epilepsy and they're taking medication at work and they get an allergic reaction to that medication at work, that would not be work-related because it's a self-medication for a non-work-related condition. Same thing with diabetes. If an employee is taking insulin at work and they have an allergic reaction to that insulin, creating an illness of some sort, that would not be work-related. Again, it's a self-medication for non-work-related condition. Or if an employee intentionally inflicts themselves, hurts themselves, that would not be considered work-related. From the previous slide, I have indicated that certain types of cases that occur in the parking lot are exempt from OSHA record keeping. They are not considered to be work-related. However, before I go into details as to what is considered to be a work-related parking lot case, I have added this slide so you understand what type of parking lot situations are considered to be work-related. First off, OSHA defines the parking lot as an extension of the work environment when it is under the control of the employer. A company-controlled parking lot is any parking area where the employer can limit access, such as parking lots limited to the employer's employees and visitors. On the other hand, a parking area where the employer does not have control, such as a parking lot outside of a building shared by different employers, or a public parking area like those found at a mall or beneath a multi-employer office building, would not, repeat, would not be considered part of the employer's establishment except for the owner of that building or more, therefore not a company parking lot for purposes of OSHA record keeping. Over the years, I have had many questions regarding what types of cases occur in the parking lot. First off, as I mentioned on the previous slide, we are assuming that the parking lot is under the control of the employer. If that is the case, work-related cases include the following: a slip or fall from the car to the building at the beginning or end of the day, such as on a patch of ice or perhaps on some sort of oil slick or something that is in the parking lot. Any injury or illness while working on the parking lot. That includes not just repair of the parking lot itself, but also or cleaning up ice or other matter on the parking lot, but actually going out to your car to pick up equipment, be it a computer, a laptop, any type of toolbox, anything like that. Any injury or illness while you're working in the parking lot would be considered work-related. Also, any incident resulting from walking through the parking lot between buildings. For example, if you have some sort of campus type of environment where you may have a factory and a warehouse and you have to walk through the parking lot to go from the factory to the warehouse, and you get injured in that parking lot, that would be considered work-related. Also, what is considered to be work-related is any injury from going out to the parking lot for a break. For example, if you have a special designated area of the parking lot for smoking, and you have employees walking out to that designated area for a smoke break, they get injured, they fall, or they get hit by a vehicle accident, then that case would be considered work-related. Now, what is not considered to be work-related, which was mentioned on the previous slide, is if an employee is injured due to a motor vehicle accident in the parking lot while coming into work on a normal commute or leaving work on a normal commute. This also applies to personal trips, such as non-mandatory lunches. For example, if someone is going on lunch break, they go out to their car and they are struck by a vehicle while they are going out, that case would not be considered work-related. However, if they went out to their car to go on a lunch break and they slip and fall, it would be work-related. Also, other exceptions listed under 1904.5. For example, the personal consumption of food or non-mandatory exercises. If they occur in the parking lot, they would not be considered work-related, therefore not recordable.